how to choose them and when you need them, how to make the access to your information easier for your loved ones if you become incapacitated, how to protect your business interests at incapacity, a review of life insurance and how it plays a part in your incapacity planning, special needs trusts, and incapacity planning for other beneficiaries. How do we define estate planning? Basically, estate planning is the managing and passing of your assets through the preparation of documents and the retitling of the assets. I like to call the process integrated estate planning because asset protection and estate planning work together to form a comprehensive plan. Having one without the other would be incomplete. Everyone should have an estate plan so that they can control who gets their asset at death as well as how and when they get them, and who controls and manages the assets that are actually passed. In addition, the estate plan covers an individual should he or she become incapacitated, which is what the subject of today's webinar is about. First, I'd like to go through the types of documents that you might need for planning for your finances in the event of incapacity, as opposed to when we'll go through your dealing with your health and your physical well-being. So the first document I want to cover is the durable power of attorney. This document names a person who we also call an agent to handle financial matters for you. Some states allow you to have what's called a springing durable power of attorney, which essentially springs into effect only in the event that your doctor signs off on your incapacity. However, being a Florida attorney, we have a recent change in the law which does not allow that. And the net effect to that is that you have to be extremely careful whom you choose as your agent, because the person's power is essentially effective immediately upon your signing the document. So with that in mind, a good Florida attorney is going to show you how to avoid any potential for abuse that new law allows. However, even though the law is pretty strict on this and there are some pitfalls to it, it's still very important to have one of these durable powers of attorney because it will help you avoid a guardianship in the event of your incapacity. Because basically what a durable power is it says even if you become incapacitated, the power of attorney is still effective. Now, this power of attorney can be used for financial or business matters. As an example, let's say you have one of these documents. Your agent would have the power to open and close bank accounts for you, maybe buy stock. The agent's going to act as a fiduciary, which means they're in a trusted position, and they have to act prudently on your behalf. And the power of attorney can also be used to, let's say, sign business papers, enter into contracts in your name, and you being the person who created the power of attorney is known as the principal. It's also important to note that the power can't be delegated. For example, I had a client come in the other day, and he wanted to make his father his agent, and he trusted his father completely. But he was concerned because his father had just gotten remarried, and he didn't want his stepmother to have access to the power. So I explained to him that he could name his father as the agent, but there was no way that his father could delegate that power to the stepmother. So the client was happy and went ahead and did the power of attorney. Another document you might consider using for dealing with financial incapacity is the revocable living trust. The revocable living trust is a way of retitling your assets, the ones you own individually, and putting them in a trust. And there are three parties involved in a trust. You have the grantor or settlor, who's the person who actually creates the trust and transfers the assets. You have the trustee, who's the person or company who manages the trust assets. And the beneficiary, which is the person or persons to whom the trust assets are managed for. Once the grantor transfers the assets and the title changes hands, then it's actually the trustee who owns and controls the assets. In a revocable living trust, which is a very common tool that people have, you can actually be the trustee. You can manage the assets for yourself because you could be the beneficiary. And basically nothing will change on a practical level. However, if you become incapacitated, you would have a successor trustee already named who just takes over and manages the assets again for your benefit. It's a great way to avoid probate after death and to keep things running smoothly in the event of your incapacity. The successor trustee would be able to pay your bills and take care of you and your financial needs. I just want to note something about irrevocable trusts. So we just talked about revocable trusts, and that's a document you can create, you can change, you can terminate, you can do anything you want with it. You have complete control. But there's also something called an irrevocable trust, which is a very good tool mostly for estate tax planning and insurance planning, sometimes for special needs beneficiaries. But that kind of trust you cannot take back and you cannot keep control or be a beneficiary of. So it may have some sort of bearing on your incapacity plan if you are concerned with potentially Medicaid in the future, or if you're concerned about your estate taxes. In addition to the financial documents, you'd need some documents to help you with your personal and health needs. The first one might be the healthcare surrogate, which is a power of attorney for healthcare and gives your surrogate the ability to make healthcare decisions for you. Unlike the durable power of attorney for financial matters, the healthcare surrogate has no power unless you're able to make those decisions for yourself, unless you're unable to make the decisions for yourself. So to recap, if you have a healthcare surrogate, you name a person who can make decisions for you, but that power will only kick in as a springing power if you cannot communicate to your medical professionals. And it's important to note that a healthcare surrogate can't override your decisions unless you have no capacity to make them. So if you are very ill but you're still able to communicate, the healthcare surrogate cannot come in and take over the decision-making power until you are determined to be incapacitated or unable to communicate. The theory behind all the documents that we've mentioned so far is that by naming and empowering other people to handle your affairs, you can avoid the need for a guardian. However, if there's absolutely no way to avoid the guardianship, then what we do is we call it a declaration of pre-need guardian, or a just-in-case form. It allows you to name your own guardian. Generally, the judge will honor your choice unless the person is shown to have a criminal record or is mentally unstable. The reason we actually want to avoid guardianship is because of the expense and the time involved, not to mention the indignity in having to be declared incompetent before a court and society. And finally, we suggest a living will. The living will is your way of informing your family and medical team that you do not wish for life-prolonging procedures to be administered to you in the event of certain conditions, like a chronic vegetative state. It's important to evaluate your religious beliefs before executing the document because there can be conflicts. Generally, it's up to your healthcare surrogate to act on your wishes in your living will. As a practical matter, the healthcare surrogate can fail to present your living will or can refuse to let it be used, and it would actually be difficult for your doctors to follow through on your wishes. I've happened to know several people to whom that's happened. So it's very critical that whoever you name as your healthcare surrogate be in agreement with your wishes or at least agree to abide by them. The documents that we spoke about name certain people to do these jobs for you. The first one we have is in the power of attorney. We already said that we call this person the agent. Who needs to be the agent? The agent needs to be someone whom you have absolute trust. The reason for this is the agent gets to stand in your shoes and do anything that you can do with your money. So from an investment standpoint, you want a financially savvy person to act as your agent. You also want an agent who's not likely to act impulsively and recklessly. The person should always have your best interests at heart and should think like you would think. The reality of the situation is that many people have difficulty choosing an agent, and some people avoid the power of attorney altogether because of it. We also have successor trustees. We talked a little bit before about a living trust, a revocable living trust. And as I said, you can be your initial trustee, but if something should happen to you, whether it's incapacity or death, you always want to have a successor trustee listed, and perhaps even several successor trustees in a line as to who's going to take over for you in the event that you can't be the trustee of the trust anymore. A good attorney will always put some sort of procedure in place to choose a successor trustee if there's no one named. But again, it's critical that you get to choose the successors and put those names down on your document. You want to make sure that the trustee is the right person to handle things for you while you're alive, but also for your future beneficiaries. In my opinion, it's actually most important that they be the right person to handle things for you, because your beneficiaries come later on, but you're the one whose money it is when you created the trust. We also talked about the healthcare surrogate, and the person that handles the healthcare surrogate is actually called a healthcare surrogate, and that person gets to make all your medical decisions for you if and only if you cannot make them on your own. This person should be on the same page with you as to how you would handle your own medical care. As a practical matter, you don't always know how you would handle something because you haven't necessarily been in the situation. But if you choose someone who has the same goals as you in terms of medical care and who thinks like you, that's your best choice. Most people do choose family, but some will choose friends who are doctors if they feel that a family member would not be able to think without tremendous emotion and wouldn't be bullied by their relatives. For instance, I had a client who had a situation where they named a family member to be the healthcare surrogate, but the rest of the family was so pushy that the healthcare surrogate found it difficult to make decisions without the family putting in their 2 cents. Guardianship, as I said before, is always the last resort for the incapacitated person because of the time, expense, and indignity involved. But again, we said you should create the document, the Declaration of Pre-Need Guardian, and name guardians. Now, guardians are actually broken up into 2 categories. You have your guardian of the person, and that's the person who's in charge of your daily activities, your socialization, your medical care, where you live. And then you have the guardian of the property who's in charge of your finances, kind of like the power of attorney. All guardians have to account to the court and are governed by the court. They have restrictions that would normally not be imposed on the agents in your power of attorney or your healthcare surrogates. And the guardians can be different people. If you don't want the same one for your guardian of the person and guardian of the property, you can choose different people. It does make it a little more difficult and more expensive of guardianship. However, if you want one person taking care of your personal needs and somebody else is better at finances, you could choose to split them up. And the court, again, will probably honor your request. Finally, one thing people don't think about is, if they become incapacitated, is what happens with your minor children. Everybody lists guardians for their minor children in their will, but what happens if you become incapacitated, you're still alive, but you have minor children? Who's going to take care of them? And I happen to have known people in this situation, and it's critical to have those choices in writing so that there's little or no fighting among the relatives about who's going to take the kids. Because the situation is going to be tragic and traumatic enough for the kids, and you wouldn't want to add to that. So you have 2 choices. You can put it in your will and have the court look at your will, or you can have a separate document that names guardians for minors. I personally recommend both. And finally, just as an aside, if you're regularly leaving your children with anyone other than your spouse, you can consider doing a medical power of attorney for the minor child and give that to the caregiver, whether it's a nanny or a grandparent. That way, they can get medical care for your children in case of an emergency. When I go on vacation and I leave my children, I always leave one of these documents for whoever's watching them, along with a copy of the insurance card, Social Security card, and my driver's license. Because that's what the hospital asks for. Because you never want to put your kids at risk by having medical treatment delayed because the caregiver doesn't have the authority to get the kid treated. If you're ever incapacitated, it's going to be very important that all the people you've named in your documents can find your information easily. For instance, your agent and your durable power of attorney is going to need to know what kind of assets you own and where they're located. They could potentially need your passwords for your online access to accounts, your Social Security number, your driver's license number, information on your disability and long-term care insurance. The agent might also need your lawyer and CPA's numbers. Digital media, very hot topic right now. Could be important for your agent to have access to your Facebook, LinkedIn, or any other social network accounts, as well as a list of domain names and things of that nature. If you've done proper planning, then you would have signed a HIPAA release as well, which allows your agent as well as your healthcare surrogate to get whatever medical information is necessary to handle things for you while you're incapacitated. And HIPAA actually has far-reaching implications. It's not just for doctor's offices. Finally, I always recommend that my clients keep a binder with copies of all their important documents as well as their identification, and they tell someone where they keep it. I'm not a believer in actually giving someone access to any of this information, but I do think it's important that they know where to retrieve it if necessary. It's clear that when a person becomes incapacitated, they need someone to make healthcare decisions for them. And it's also clear that you will need someone who's going to pay your bills and take care of your house. However, what people don't actually realize is that if you have a business and you become incapacitated, then who's going to be running your business? And what's going to happen to the income that you had from that business? Not to mention the employees who might lose their jobs. What you might consider is having what's called a specific durable power of attorney. You put that document in place specifically for someone to run your business or deal with, let's say, your real estate holdings. This person can be a key employee or a business partner or whomever you trust. Doesn't have to be the same person who would handle your bank accounts and other financial matters. People with larger companies or with partners often put in place a business succession plan that will deal with incapacity and eventual death. It might involve a buy-sell agreement, life insurance, disability insurance, and other documents. The key here is you want to preserve the business so that it continues to support you and your family, or long enough that it can be sold as an active business and not at a fire sale. Providing income to your family while you're incapacitated could be very critical. Part of a well-thought-out incapacity plan is insurance. I'm not licensed to sell insurance, so I can't advise you on insurance. But I'd like to give you an overview of the types of insurances that might be relevant to incapacity planning. And then I suggest you discuss these with your insurance professional. There are several types of insurances that play into the plan, and you may opt to have some or all of these. Health insurance, as we know, is essential for everyone, and come January, it's going to be mandatory. It's important whether your incapacity is mental or physical, because this insurance is going to defray the costs of your care. And depending on your age, Medicare might actually be part of this plan as well as part of the health insurance. And if you're below the poverty line or you qualified for another reason, Medicaid could be part of this plan. The other type of insurance you might consider is disability. Disability insurance can cover your loss of income in the event of a disability, even if you're not completely incapacitated. So there will be some companies will give you partial as well as disability coverage. There's also short-term disability, which generally covers the first 90 days of a disability, and long-term, which covers everything after that up to a certain period of time. So generally, disability is not going to substitute 100% of your income, but it can go a very long way toward keeping you and your family from being out on the street because you're unable to work. It's also important to note that disability policies can vary very greatly. And if you have one, you always want to have it reviewed by your insurance professional to make sure it's covering your needs. For instance, I've had a disability policy since I'm 25. I actually spoke with my disability agent today to see about potentially increasing coverage, because as your income increases, you want to try to increase your coverage when they allow it. My policy happens to be an individual policy, which means that no matter where I've worked, I've actually taken that policy along with me, and it's not associated with any employer. Sometimes you have your disability through an employer or through their employee benefit plan, so if you leave or you're fired, you might lose your coverage. It's important to know that. You want to verify what the coverage is, how it works if you're no longer with that employer, whether it's by choice or otherwise. There's also something called long-term care insurance, very popular in Florida. This type of insurance is used to help defray the costs of home care or nursing home care. There's limitations on the coverage, so it's important, of course, to evaluate the policy and make sure what you're actually getting. But with average lifespans increasing, it's very probable that most people will end up needing home care or being in a nursing home. So I would certainly look into it. You have to do a cost-benefit analysis, of course, to see if it works for you, if it's necessary for you, at what point in your life you would choose to buy the long-term care insurance. We also have something in Florida through the Florida Bar, which might be available in other states and for other professions, that I wanted to mention. It's called catastrophic insurance. It's kind of like a secondary insurance, and it will pay things over and above what regular health insurance will pay for. So that could be pretty critical. If that's available to you, you may want to consider it. I know for the Florida Bar, it's available to the attorneys as well as their extended families. Finally, you have life insurance. Now, life insurance we all think of as paying out at a person's death. However, if you have cash value in your policy, if you become incapacitated, you may be able to use that cash value to help support your family, or take a loan against the insurance to help support your family. So life insurance can be important in that respect as well during incapacity. There's something called special needs trusts. I've mentioned it earlier. Usually you don't have a standalone special needs trust. However, you very often will incorporate the special needs trust into a different type of trust, whether it's your living trust, whether it's an irrevocable trust. The special needs trust is basically to plan for potential incapacity or disability of one of your beneficiaries. For instance, if you have an autistic child or grandchild, that child might one day, if they're not already, qualify for government benefits. So you wouldn't want to disqualify them by leaving them money. So what you do is you create this very special trust, and you put somebody in charge who you trust would do the right thing by the beneficiary, by the special needs beneficiary, that is. And this trust will pay for things that are not covered by government benefits, whether it's Medicaid or any other type of benefit. Essentially, it covers what we call luxuries. So you can still help out the special needs beneficiary without disqualifying them from government benefits. All that we've discussed today is regarding incapacity planning. This type of planning is part of estate planning, and you should always review your estate planning whenever you have a life-changing event, whether it's marriage, divorce, or something, new child. Whatever it is, you should always review. Otherwise, you should just review standardly every 3 to 5 years. Also, if you move to another state, every state has its own laws, and while some documents might be valid in all states or both states, you want to make sure to have it reviewed, because if you can take advantage of laws from the new state, or if things are radically different from one state to another, it's important that you potentially amend or even replace your documents when you move to a new state. For instance, we talked about the Florida rule that you can't have a springing power of attorney after October of 2011, I believe. So if you come from a state that has that, you want it reviewed to make sure that that power of attorney will still be valid.